Hi and welcome to Lex Novus. The buzz all of last week has been about the passing of the EU's AI Act. This is the world's first comprehensive AI legislation meant to regulate all things AI within the EU. But does it have implications to AI developers and deployers outside the EU?
Yeah.
The EU Act or regulation has been in development since April 2021. Over the years, through consultation with various stakeholders and the development of AI tech, the draft regulation has evolved, and the version that was passed last week is quite the behemoth. The regulation covers definitions, assessment requirements, prohibited AI systems, and more. It also defines artificial intelligence and categorizes them according to risk. For today's episode, we are only looking at high-risk AI, that is, the most regulated under this Act. High-risk AI systems are defined under Article 6 of the regulation. The definition, however, is more of a scope than it is a definition. If you want to know if your system falls under this definition, you will need to reference the Union Harmonization Rules. These rules are listed in Annex 2 and cite 19 separate directives and regulations. Once you've determined that your system falls within this definition of high risk, you may want to consider the overarching scope of the regulation provided for under Article 2. Point 2 sub 1a stipulates that if you are a provider in the EU market, and this includes general artificial intelligence systems, the regulation will apply to you irrespective whether you are located in the EU or not. For deployers located outside the EU, Point 21c stipulates that the regulation will apply as long as the output of the system is within the EU. Article 2 also creates categories described as distributors and importers, which are entities within the EU bringing in AI systems into the Union. Interestingly, there may also be applicability to manufacturers of tools used as components in AI systems. Two interesting points to note about the regulation scope is that in terms of individuals, the regulation applies to affected persons located within the EU only. Secondly, the regulation does not apply to foreign public authorities or international organizations on a condition. The condition is that they provide adequate safeguards to protect fundamental rights and freedoms of individuals. I think a lot of questions are going to arise in terms of applicability of this point, considering the varying standards of rights relating to freedoms across the world. If you are looking into Article 2 for the applicability of the Act, you may also want to look at the non-applicability listed there, such as for purposes of scientific research, testing of AI systems, pre-launch, this with certain caveats of course, personal and non-professional use, and free and open source systems unless they are for high-risk purposes. For companies looking to remain outside the EU but still want to deploy high-risk systems within the Union, Article 25 makes it mandatory to appoint an authorized representative. This authorized representative will have significant powers and has a primary focus on compliance with terms of the regulation. In fact, the authorized representative has not the power but the obligation to terminate the agreement or mandate with the external provider if it considers or has reason to consider that the provider is acting contrary to the provisions of the regulation. The category of importer is internal to the EU, and significant obligations are placed on them as well in the context of high-risk AI systems. Importers are required to carry out a conformity assessment as set out for in Article 43 for high-risk systems. Similar obligations are placed on the category of distributors, described in Article 27, with additional unique requirements, such as obtaining CE markings for the product. These types of obligations that apply to importers and distributors will naturally require AI developer companies operating in this high-risk space outside the EU to come up to EU standards if they wish to continue servicing this market. This may also include manufacturers of components of AI systems, as Article 28 addresses responsibilities along the value chain. You may also want to consider that depending on the space your AI system operates in, the system could be subject to mandatory assessments. For example, if the system is being deployed in the sphere of public law or services, or within creditworthiness or insurance, a fundamental rights assessment under Article 29A may be required. This is over and above any other form of assessment that may be required under other regulations like the GDPR, although there are some provisions to avoid overlap. So are there implications for foreign entities from the enactment of the EU AI Act? The short answer is yes, but the extent to which those implications will be felt are heavily dependent on the nature of the AI system that is being developed or being deployed. In any event, while the regulation is technically passed, there are still a few steps before it is formally published, and from there, the regulation will take up to 3 years to be fully implemented. That is disregarding any developments that may come into play in that span of time. Also, considering the fact that there's going to be significant interpretation and teething issues at the beginning and ongoing from the point of implementation. You can expect a lot more developments in this space, and it will be interesting to see how this legislation interacts with other AI legislations around the world as they emerge. For example, the US state-level laws and China's governance framework. Catch you next time on Lex Novus.
Yeah.